Hey everybody, it's almost agreement time. As I've alluded to about 10,000 times already, we have, like 120 people to talk to by May, and it's going to get pretty crazy. So we're almost in agreement at gmail.com. We are on Facebook, Twitter, and YouTube. We have a website, almostinagreement.com. You can go there and get all the available episodes. As I've mentioned a number of times as well, I've got kind of a jobs description cheat sheet, and today's episode will hopefully help fill in some of the blanks, because this is where we get into some of the stuff that I really have no idea on. So we'll talk about that here in a little bit as well. Please go to your local or your favorite podcast provider and get on there and do some liking and sharing and 5-star reviewing and whatever it is that you can help me get spread the word out, get more people listening, because as I always say, it's important to know what the job is as well as who the people are that are asking for the job. So hopefully we'll take a couple chunks out of that today. We'll let this intro play itself out, and then we'll have a conversation. All right, everybody. Today I have Deno Cole, and he is running for Chancellor Division 2, Circuit 6. Like, where's the 6 come from? That's
actually Chancery.
Chancery. Okay.
Chancery Court, not to be confused with Circuit Court.
Right. And that's one of the things, again, that's one of the things confusing. And I've got a lawyer friend that I talked to, and he gave me the Cliff Notes version of the difference in the courts, and I want to talk about that for a little bit. But let's go and start with the history of you as far as, are you a Knoxville native, been here forever, kind of that kind of thing, and then what got you into, because obviously you have to have been a practicing attorney for a number of years. It's a requirement locally.
The requirements are a state requirement, because you're actually a state official,
right,
as a judge, as a Chancery Court judge or a chancellor. And just to go back to your initial question, you asked about what the 6th district means. There are a number of judicial districts in Tennessee, and Knox County happens to be its own judicial district. You know, if you were in Union County and you were the chancellor, you would also be sitting in Claiborne County, Campbell, Scott, and Fentress, which is a pretty large area, but we've got almost 500,000 people in Knox counties.
And so I guess to broaden the question then is, so this is a state employee, not a county employee. It's a fine line as far as definitionally, but this falls under the purview of the state. And so that brings up a question that I could totally have already known the answer to, but again, I'm confused all the time on these things, chasing them down. So, is your general on the August ballot, or your general going to be back on the November ballot?
The general will be in August. The primary will be May 3rd.
So you're going to be with all the Knox County regular stuff, even though it's a state seat. See, these are the things that are weird to me, because you're going to be a general for the state position while all the primaries for the state stuff are on the August ballot as well. Right.
And what's pretty crazy about judicial positions is that they're 8 years.
Right, so, which is why we have such a crazy ballot coming up, because we have 4 circuit, 3 criminal, 3 chancellors, and a bunch of general sessions, five general sessions, and then all their clerks and the register of deeds and everything else, a bunch of school board. It's, again, I make the joke all the time. Like, if I try to get everybody, because we haven't, I'm still looking, I'm getting it every day on the updated petition list and stuff like that. And if I try to get everybody, it's 100 plus episodes that I'm going to have to do in like 90 days.
And then you have the juvenile court judge too on top of that.
Yeah, there you go. Yeah, another one we missed, of course. Okay, so again, so are you Tennessee native, Knoxville native? Like, give me the last 30-ish years.
Okay. Well, I'll start from where I am now. I'm 50 years old.
Okay.
And
I'm good with the 30-ish.
Moved to Knoxville when I was 4. So okay. I guess Knoxville native is good. Graduated high school from Knoxville. Went away to college, to military college, the Citadel in Charleston, South Carolina. Okay. Went to law school in New York. Came back here to start practicing. And been practicing since 97, so 25 years of law practice. And you also asked earlier about requirements to be on the ballot. Right,
so it's 5 years in state?
Tennessee has extremely low requirements. Some states require you to have been a lawyer for 10
I was looking at that. Okay,
for 10 years. Yeah. Tennessee, you have to be 30 years old and a licensed practicing attorney. That's it, which I think is too low.
Specifically for chancellor?
For all judges.
At least 30. Resident of the state for 5 years. That's where I was getting confused.
Oh, yes.
Resident of the state for 5 years in the current district or circuit for one of those 5 years, the most recent of the 5 years. Oh, okay. Well, then I need to correct some notes that I have elsewhere because I had it written down as 5 years practicing in state.
There's a lot of states that require 10 years practicing, and states like Missouri even have a cutoff. Once you turn 70, mandatory retirement. Tennessee doesn't have a mandatory retirement.
Yeah, I could get down on that. I mean, I don't trust my dad to pick out a new car. Why would I trust him to put somebody in jail or not? Okay, Ed, so so from practicing attorney to getting into a judge, is this your first, because again, the whole judicial part of politics and stuff like that is way above my head, and this is where I'm trying to catch up ground. Is this your first run, or are you sitting right now? Because I don't even know that part right now.
Okay, I'm a practicing attorney. This is my first time to run for judge. What's also an interesting rule is that you can't start raising money until a year before the primary. So I couldn't really officially announce and start having fundraisers. You can unofficially tell people you're running, but you can't really
official duties. You can't assign a treasurer yet. If you can't assign a treasurer yet, you can't take any money. Because if you take any money, then it gets real weird real fast. Right. That makes sense. Okay. Well, I mean, it doesn't necessarily make sense when you have, Mary Jacobs and the sheriffs have been running for 3 years almost, is what it feels like, at least already. I mean, there's already talks of Trump running in 24 and stuff like that. It's like, can we get through the end of this year first, and then we'll start talking about 2 years out. So what made the jump from coming out of practicing to wanting to actually be on the other side of the bench, for lack of a better word?
Well, I've always respected the judiciary. I had clerked with judges before when I was in law school, and always had a high respect for good judges, especially when you go into court. They follow the law. They don't play favorites with anybody, and I've always seen myself as a fair-minded person. I've also been kind of a law nerd. I enjoy reading law cases, even if they don't pertain to things that are in the areas of where I'm practicing.
Right.
And I was active in groups in law school that were big on constitutional interpretation, and I got to do a lot of cool things in law school and meet Supreme Court justices and big lawyers.
Because again, this is, for me, I mean, like the whole premise of the show, you said you've listened to a few episodes, but the whole purpose of the show to me is I assume I'm fairly normal in this community. A lot of people will come up to this ballot, especially as big as it's going to be, and they're going to vote for who their neighbor told them to, or like there's a lot of seats that I don't think that we in the general public really understand what we're hiring for lack of a better word. I always kind of put that as we are the hiring manager as a community. And so the first part of that is what is the job. And so let's break that down a little bit, because again, the Cliff Notes version that my lawyer buddy gave me is generally the Chancery Court doesn't have a jury. It's more, and I don't mean this to be offensive at all, but it's kind of like a Judge Judy arbiter situation. The people come up and they state their case, and this judge gets to make the decision as to, and then again, there's a specific subset of what you're allowed to see in the Chancery. We'll get to that in a second. But it's more of that. It's not a jury appears. We don't have jury selection kind of stuff. It's more of a case presented. You, as the chancellor, would be able to make a decision on the facts presented and go from there. Is that fairly accurate? Again, I don't mean to Judge Judy it, because I know that's probably a little offensive, but that's that, again, trying to put it in layman terms. People know who Judge Judy is. They don't know what a Chancery Court judge is.
If you don't have a thick skin in this business, you don't. You shouldn't be a lawyer.
Tread a little lightly.
But I would actually probably equate a Judge Judy example to General Sessions Court, because that's your small claims court where people oftentimes don't have attorneys representing them.
Okay.
In Chancery Court, most people are represented, so they do have the lawyers presenting the proof. About half of what the judge does is hearing motions. So you might have one side, the lawyer typically filing motions to dismiss the case or part of the case because the law is not with them before all the facts come in. That's called summary judgment. You may have other types of discovery fights. One side's hiding the ball and not turning over discovery. But just to back up, Chancery is all civil, just to make it clear.
Right, because again, the layman version he dropped, let's see where it is here so I can make it his fault, not my fault if I'm totally off target. You don't need to say his name. You might know him from around town. He's been practicing for a while. He told me that you beat him once. But
he's gracious.
Because it's more than once.
No.
But non-economic damages such as contracts, property dispute, divorces, and the like. That was his quote on it. Yeah. And so I don't know. Expand on that. Help me understand, like some of the cases that come to. Okay, let me ask a question first, and then we'll expand on it. Have you been one of the attorneys you were just referencing going to Chancery Court on behalf of clients?
Yes.
Say practice court. So you're familiar with the current judges that are in seats?
Absolutely.
Okay. I wanted to know that part. Now let's expand on like some of the cases that you've done as an attorney or that this court would see as much as we can. I know we got to be careful about some of the parts.
Oh yeah, no problem. It might be easier to talk about the difference between circuit and chancery. Chancery court is a court of record, which means that you often have a court reporter that types up the transcript of what's being said in the courtroom, and then you can go to the Court of Appeals if you're dissatisfied with the judge's ruling, and there are certain standards for that. But typically in circuit court, you do get juries. Car wreck cases, medical malpractice cases, you're not going to see those in Chancery court.
Okay.
Now, if both parties agree, Chancery court could hear those cases, and Chancery court can hear cases by jury. But when they hear a case by a jury, which is extremely rare, the jury actually determines questions of fact. So let's just take a will contest, for example. Say somebody challenges a will and says, hey, this will was a forgery.
Right. My dad hated my sister. There's no way he gave her all my stuff.
Right.
Got it.
Well, let's just say that the sister then forged this will and said, hey, here's this will that gives me everything. Then the jury might be tasked with the question, did the decedent, the person who died, your father, sign the will, or was it signed as a forgery? Right. And that would be the only question. Then the judge would apply those facts to the law and say, well, they found it wasn't his signature, so the will's...
So the jury is the one that is interpreting the evidence into whether it's fact or not.
Yes.
That is not the job of the judge in those style cases.
Right. If they have a jury trial in Chancery court. Now, the lawyers at the end of the proof and the end of the trial can say, well, the jury totally got it wrong. And if the judge finds by, fancy word, preponderance of the evidence, which is more than 50%, that the jury got it wrong, the judge can actually overturn that jury verdict. And then, of course... that doesn't happen very often, but occasionally you do get juries that do things that are a little off base. I think juries in general get it right. They don't always do, but for the most part, they use their common sense. That's why we like juries in our society.
Right. Yeah, because it's again the premise being it's supposed to be my neighbors, not people that have a specific lean one way or the other and stuff like that. So it's just. What's the word I'm looking for here? Theoretically, it's almost like voting in the sense that it's as much as it's not a popularity contest, but it is this is my neighbors making the decision, not some other person over there that's put there for whatever reason. Okay, so wills is definitely one of them. Like we already talked about, divorces.
Yeah, right. I can go through a list if it'd be easier.
It might be, because I get it. Like, if I'm understanding the role correctly, it would be another version would be, let's say me and my neighbor can't decide where our property line is, and that may be.
That's right on point. You could actually file that in circuit court as well, but you would probably see that filed in Chancery court just because chancellors are going to be more familiar, and that's going to be a more common.
And so the lawyers do the thing, and they present the evidence, and the surveyors come out, and all these different things go on, and then at the end of it, the judge in this case will say, this is now the line of record essentially, and so now you have documents of it, and then if my neighbor and I want to further dispute it, it changes course, but at least we have the starting point of this is what the Chancery Court has determined on the evidence that this is the line. So this is basically a starting, what you called it, a court of record. Yeah. We get the record on the books, and then we can battle it out over further things elsewhere, but at least we have an official starting line, I guess, for lack of a better word.
Right. And appeals are actually, it's hard to overturn a judge unless the judge goes way off base, doesn't follow the law, or the evidence clearly goes against what the evidence shows, what he found or she found. So, like I said, appeals are also very expensive, and a lot of times people just can't afford to do it. I mean, attorneys can charge $20 $20,000 just for an appeal.
Oh, I know. My guy's expensive as well.
And
I texted him one time. He sent me $40 bill. It's like, you owe me $40. It's like, what? Anyway.
So, but you asked about a lot of things that they did. One thing that Chancery Court is over is the probate court. But in Knox County, you have the clerk and master who kind of hears the first level of probate matters, and if somebody takes an exception to his report, then the chancellor would determine whether or not the clerk and master got it right.
Okay.
And will contest, what we just talked about, probably 40% of what a chancellor does is family law. And that's probably about 40% of what I've been doing in my private practice as well. Divorces, adoptions, custody cases with parties that aren't married, post-divorce, so you've already gotten divorced and now you're fighting over a change of how the schedule should be for a child, alimony, the number of family law issues. Contract law is what a lot of people think. You might hear that a chancellor does equity, but first and foremost, a chancellor has to follow the law and follow the statutes in Tennessee if it applies to the case. But there's also a body of law that the courts have developed through the Court of Appeals, and you're charged with knowing it and following it as the chancellor.
Okay. That gets us. That last one started to get me a little spaced out because that's.
If I went off in too many directions.
No. It's not that. It's just that it's again. Like I readily admit my ignorance, especially in the legal system. Thankfully, I haven't had to get a firsthand education in a lot of it for any purposes. But just like I don't know what probate court. I don't know what that means.
Oh, okay. Sorry about that.
No, it's okay. Again, this is I always joke about it. It's like, not that I'm stupid, but I'm comfortable that I don't know things. Like I'm comfortable being like, I don't know what that word is. I can't remember. I had Becky Massey in here, and she said something. She said something like about summer session. They send all these things to summer session. It's like, what is? I mean, the logic would be, oh well, they go do some stuff in the summer. Well, they don't really do summer session. It's really just they shelve it, and we may come back to it later. And but they say the phrase all the time, and it's like everybody's expected to know what it is. It's like, I don't know what it is, and I don't know who to ask, so I'm just going to be dumb, and I'm going to ask the person that's saying it.
I'm glad you do, because I take it for granted these terms are terms I use every day, and clients call me up and they already know what they mean because they've already researched it on the internet. And so probate is real simple. If you pass away, and whether you have a will or not, then you open what's called a probate estate, and that's how your estate gets administered. So your property gets divided up, your creditors get paid, your heirs get their share, and that's going through the process of probate.
Right, so that's what you mean by there's a mountain of case law on the books already, and so,
For all cases, not just probate, but for all law cases.
Okay, because again, again, my dad passes and doesn't have anything written down. I have a brother and a sister, so there's three of us, and so there's...
Intestate succession, there's a statute, it says this is how it gets divided.
Right, so it's already existing, so you're just kind of helping apply it and getting all parties on board with understanding it. And then I can argue, it's like, no, my dad liked me better, and then I can try to present some evidence or whatever. But
if you don't have a will, then you just follow the law. It doesn't matter if your dad hated your siblings but loved you the most. If you didn't have a will, you follow the law.
Okay, so I think it's true, but anyway,
no comment.
Okay, so we talked a little bit before we got started, because there is, when we get into judges specifically, I think the DA falls under a little bit of it too. I can't remember, but judges specifically have some ethics in campaigning that most other candidates don't have to deal with, as far as some of the things you can and can't talk about because of the position. So we talked about, like I said, we talked a little bit about before we started, but I think it's an interesting thing that I think people should know, because I think it could affect some perceptions of people, because we're so used to certain things, like, again, just off the top of my head example, Trump goes to Georgia or whatever and says, vote for Marjorie Taylor Greene. That's normal, where that is not something that the judges can do, whether it's inside the judging part of things or even outside otherwise. So I can ask you all I want, but you couldn't answer if I said, who do you like? Who would you prefer to be the mayor coming up? You can't answer that question.
Right.
And so just kind of expanding on that, some of the rules that you have as a candidate and how you get familiarized with those going into this, since you're new at it, as far as the campaigning part.
There's a set that the Tennessee Supreme Court, they've adopted a set of ethics for judges, and there's also a set of ethics for lawyers. I still have to follow the lawyer ethics as well. And under the judge ethics, there's what are called the judicial canons, and the judicial canons specify that, like you said, you can't endorse other candidates. But the other thing that is probably a welcome, especially in this area, you don't see a lot of negative campaigning as much in East Tennessee that you might in other parts of the country.
We used not to. We'll see. It's starting to shift a little bit, but we'll see.
Sure. I still think that it doesn't necessarily sit well with a lot of folks, but you're not supposed to have negative campaigning against another judge.
Okay, so basically the idea is there is the canon of judges, and if you want to be a judge in the campaign process, you have to act like it.
Right. But I mean, you can differentiate yourself and say, here's why I think I'll be the better
right, and I do want to get to that part here in a second. I just want to understand the ethics part before we start. I'll probably still screw it up and ask you a question I shouldn't, but I just want to try to get a feel for this ethics part because as mentioned, I hope to get, because at least as of last time I checked, which is earlier today, there's only in the 3 divisions for Chancery, there's one person running for 1 person running for 3, and like 3 running for 2. And so,
well, I can tell you what I think. What I understand is that there are 3 parts. They call them parts or divisions. It's fine, but they technically, I guess, call them parts locally. But part 1 is Chancellor John Weaver, and he's been a multi-term chancellor, and I understand he's running unopposed.
Right. I can pull it up.
And I'll skip to part 3 because part 2 is the race that I'm in. Part 3 is Chancellor Chris Haggerty. He was appointed by Governor Lee. He took over for Mike Moyers, who was the previous chancellor. I understand that no one has pulled a petition for his petition. As
of today, I've got it up on the screen for us. That is currently the situation.
And then part 2 is the race that I announced that I would be a candidate back in May, and actually pulled a petition and have already qualified to be on the ballot, returned the petition, along with the incumbent, Eddie Pridemore, and the other person that has announced is a former law director by the name of Bud Armstrong, who announced after me. And so that it's going to be 3 of us that at this point will be determined in the primary on May 3rd. That there hasn't been a Democrat that has
independent
or an independent.
Right, and I have a specific question about that for later. But I understand what you mean by we have incumbent situations in 1 and 3, and so it's not a real campaign plus to run in 1 or 3, especially since everybody seems to be Republican so far that's pulled. But is there a functional difference in 1, 2, or 3? Is it just there's 3 Chancery Court judges and they rotate cases or whatever, or is it like a geographic that this section of Knox County is 1, this is 2, this is 3?
No difference. Knox County is... I wouldn't say unique, but if you file a case, whether it be a boundary dispute or a divorce or a breach of contract, construction law case, that's another thing that they hear a lot of. It gets sequentially placed in a part or a division.
Okay, so as of day 1, after everybody takes their new seats, what is it? Part 1 gets the first case, part 2 gets the second case, part 3 gets the third case, part 1 gets the 4. It just rotates.
Correct.
And so for all my server friends out there, it's just like rotating seating at a restaurant. Get it?
And you can essentially pick your, if you send your law clerk or your staff to the courthouse, you can pick your chancellor, and you can do the same thing in circuit court. Now, if you're in Chattanooga, which is Hamilton County, it's its own judicial district. It's randomly, just like in federal court, it's random. You don't know who your judge or chancellor is going to be. They have 2 chancellors, I think, in Chattanooga, but you can't, if somehow you have a personality conflict, or you know that this chancellor has a reputation for starting at 50-50 custody in a custody type case, divorce case or post-divorce case, then you might want to have that chancellor is the one you might select if you're filing for divorce.
Right, because that one works for your client. And so, okay, that's weird. I don't like that. On the surface. Like, I get it, to say that, I'm going to go in, and I've been working in Knox County for a long time, and that guy used to be a partner in my law firm, and he left to go be this judge, and so that would be inappropriate. So we're going to avoid him and say, hey, we can't have him as our judge in this one because of the history. But to say that I like that guy better because he tends to side better with the things that I'm after here, I find that a little bit problematic, I'd say.
Yeah, there's definitely an issue with it, and I don't know if it's been raised in recent times. But just going back to your example, I've got lawyers that practice in my law office, and I think after a certain time, I would be allowed to hear their cases, but it would have to be a number of years, I think, before I would ethically be. But I then would probably disclose it to the other side. Hey, listen, 5 years ago, his office was next to mine in the same building.
I signed his check, so just so you know, I've seen him since his kids were young and stuff like that. So, and again, I think that's one of the weird isms that is just natural in the system that we have to deal with, and we have to figure out how to be transparent and clear about and make sure that there's no accidental biases. I was like, anyway, I'm not going to go down that road. Okay, and so ethically, we are allowed to talk about the differences.
Sure.
And how you feel like you could be better in this seat than Mr. Armstrong or Pridemore. And you said Pridemore is the incumbent as well?
That's correct.
Okay, I need to make a mental note of that so that I don't come off looking stupid when I talk to him. And so, I guess to be broader than the two of them specifically, what's the word I'm thinking of here? What kind of range does an individual judge have in the job, as far as, again, as this hiring manager kind of look like? So this is what I struggle with a lot of positions on how to verbalize what I'm working on here is that, as you mentioned, there's a lot of stuff in case law already that it's just literally like this is already kind of put in place. It's just I apply the things that are in front of me and go from there versus, well, this one's got a little more gray area. I can, like, what can a personal individual do that shows that range, I guess, is if you could think of an example, maybe. Why would I be qualified to apply the law? No, not necessarily why you would be qualified, but what is the, again, like I said, I have a hard time asking this question because I don't know how to word it well. Like a court clerk, for example, which are also on the ballot right now. I've been trying to read up and trying to understand what their job is, and it seems to me that they're kind of the master stenographer paperwork person, that they keep up with all the records. It's their job to, if you as an attorney come in and be like, hey, I need records from this past case or something like that, that's the job. And I get the feeling that it's a pretty narrow window of what the state or federal government allows them to do. It's not like you could come in and they don't like you or your client and be like, well, I'm not giving you the paperwork. They have to give you the paperwork. That's the job. And so, like, one of the questions I've been asking a lot of people trying to get a better understanding of this, how much breadth is there for an individual to change, to be different in the job, I guess, is what I'm trying to get at. Because again, at the court clerk or the trustee, those kind of examples where it feels like at least it's a very narrow window of what you can and can't do. And so if two people are trying to fit inside that window, there's not going to be a lot of difference. They might have different personality or something like that, but as far as functionally doing the job, that's kind of the range I'm trying to get an understanding of.
Well, I don't think that there's a whole lot of discretion, but I can tell you this.
That's a good word, discretion. I need to add that to the vocabulary.
So, some of the things that I guess occasionally have been frustrating to me as a practitioner are judges that don't give you a decision right away. I had a judge that sat on a case for a year one time, and my clients are calling me weekly sometimes. What's going on? What's going on? You don't want to call the judge's secretary or judicial assistant and say, hey, when am I going to get this decision? Because it may negatively affect my client that I'm being pushy. So, as a sitting chancellor, I would endeavor to try to get decisions back in a timely manner, so they can either move on with an appeal or take the decision, and hopefully both sides understand and respect whatever decision I were to come up with.
Okay.
Another thing is, starting court promptly, because sometimes there can be a backlog if you're not, and if you're not in the courtroom and hearing cases on a regular basis, there can be a backlog, and it can take a long time just to get your case heard. There's no parameters. The administrative office of the court has certain parameters of when court cases are supposed to be set, from the time they're filed.
Right.
But they don't. If you don't do it, they don't kick you out of the job.
Right. Because again, logically, it makes sense, especially in Chancery Court, where usually there's an attorney on both sides, and getting like I have a hard time getting one person to come sit down in the room with me consistently and getting everybody's schedules on the same page. I could imagine it's even worse when you have this attorney, because again, like my buddy he's in Nashville every once in a while doing cases. He's down in Chattanooga doing cases. He's got cases going on here, and it's like, well, the standard is within a month or whatever like that, but his schedule, he's already got things on the books, and we got to figure out how to get your schedule, his schedule, and the other attorney's schedule all lined up. And so that does make sense that there's flexibility there. But again, I think it makes sense that a priority of being trying to get them on, get them moving, get the people that are involved in it the resolution that they're, maybe not the resolution they're seeking, but a resolution so that they can move on with whatever's going on.
And you also have to be understanding. I know things happen, and as a practitioner, sometimes things come up, people get sick, issues happen with your family, and you might have to have a continuance. So you have to understand what goes on in the real world as a practitioner, and I think what makes me stand aside from my opponents is I've been doing it for so long, and I know what goes on behind closed doors. I know what it's like to negotiate. I'm also a Rule 31 listed mediator. I've been through that training, both for general civil and for family law cases. And I've done tons of mediations, and that's something that judges generally don't get in the middle of, but you understand how the real world works. And so when a case does come in front of you, sometimes you can read between the lines,
right,
and you have that experience that maybe somebody who hasn't had all the cases that I've had, they're in that ivory tower, up at the court,
right? It's
up
easy
on the bench.
Right, I get what you're saying. As far as it's easy to just take literally the word said and leave it at that, and not understand, not even take the time to think about the broader picture of an individual or
sure,
the circumstances at play. Okay, again, I'm
and I can answer it a little bit further too.
Yeah, please go on. I'm running dry because this is all new territory for me.
No. Well, another thing is your demeanor. I always respected judges who treated me with respect and treated my clients with respect. And I am disappointed in judges who don't, and also disappointed in judges who are, sometimes I perceive, too hard on folks that can't afford a lawyer. Because in Chancery Court, sometimes the client gets fired by the lawyer, or they quit paying the lawyer so they can no longer afford to have a lawyer. Now they're representing themselves. And while you can't help the litigant, you can't give legal advice as a judge, you can at least give them enough courtesy and guidance of, hey, do what you can to try to get another lawyer, but if you can't, then here's how it's going to work.
Right.
So they understand the procedure at least, and not be out there flailing and feel like the whole system's against them.
Right.
I think that it's important that people trust our legal system. I think we've got the best one in the world. It's not perfect, obviously. A lot of people criticize the criminal side of our judicial system sometimes, where some people they perceive.
Well, I think you're right. I think people run it all together. They think it's all one thing.
Right.
It's all the same set of people doing the same things. And so there are some out there that, it's just like anything else. If you're real about it, there's some bad people out there. There's some bad people that end up in places they probably shouldn't have gotten.
Right.
And they make the people that actually do a good job look bad. And it's, I don't know, just like anything else, it's everybody tells the story about the bad experience at the restaurant they had, where even if it's okay or good, they might not tell that story because it's not as fun a story to tell.
Well, yeah, and I'll say that the vast majority of lawyers are ethical, and they work hard for their clients. I'm a former, hearing officer for the Board of Professional Responsibility, so I actually heard the cases when lawyers were turned in for violating the ethical rules, and so we would have trials over those lawyers. And sadly, I've actually signed orders that disbarred lawyers or suspended lawyers, or found that they didn't behave unethically. And one of the things that a chancellor does is actually they will hear the appeal of either the board or the lawyer through ethical complaints. And so, having had that experience as a hearing officer, and I've actually represented lawyers before the board as well that have been charged with ethical complaints, and also lawyers trying to become, or law graduates trying to become lawyers through the Board of Legal Examiners. It's called the BLE.
Right.
And chancellors could technically hear their decisions as an appeal.
Okay. Because again, this is one of those broader things that I think a lot of people struggle with. Because one of the things that I've had personally is, once upon a time I was working at a place and we were trying to do a thing, and I had a legal question about it. And it's like, this is one of the things that I struggle with. Again, this is a layman issue, I suppose. But I think it's weird that I have to pay somebody to get an answer to a legal question. Like, that's one of the problems that I have, is that it's like, hey, I'm not talking about like a very simple, basic, like, yeah, I understand I can't shoot my neighbor. I get that part. I don't need to ask anybody, or more better yet, if I ask anybody, they're going to answer that question free of charge. But like, we were trying to do a poker tournament fundraiser thing, and it's very gray area because it's not for profit and all this different kind of stuff. And so I was calling around, and so I ended up with the assistant district attorney of the state of Tennessee, talking to them, and I can't get a yes or no. Like, nobody gives me a yes or no. I talked to the sheriff, I talked to KPD, I talked to everybody I could talk to that I could think of that made sense, that could answer the question. And nobody would it was either consult an attorney, or some really vague, weird answer that didn't give me a yes or no that made me feel confident that I could or couldn't do a thing. And I think that's one of the weirdisms for me as a layperson, again, is trying to understand where I can go. Not that this is necessarily in the job title. It's just I don't get to talk to a lot of lawyers, so I'm going to take the chance. Is how a layperson can pursue some insight on a situation without having, because again, like, I mean, you already mentioned it. It's like, it's in part of your job, if you get the job as a judge, is to, or at least part of your view on it, at least, is that if someone for some reason doesn't have an attorney, to give them a little bit of grace in it because they can't afford it or something like that. And that's one of those things that's frustrating to me as an individual. I hate, like, I get why there's so much gray area. I just hate that there's so much gray area all the time when we get into legal manners, because I always, like, I guess the conclusion that I've come to is that when you ask a lawyer whether something's legal or not, their answer is whether they'd be willing to take the time to defend you if you got in trouble for it. That's become my take on it. And I don't know, I find it kind of discouraging when I'm trying to understand better on I don't know, maybe it's my fault for playing in the gray areas too much, but it's just kind of discouraging that I can't get a straight answer sometimes.
And sometimes you can't get a straight answer until a court makes that determination. I mean, think about a case that works its way up to the U.S. Supreme Court, for instance. You might have a lawyer who gave a litigant an opinion and said, here's what could happen, here's what I think might happen, and then the judge perhaps goes in a different direction. And then there's an appeal. Well, you might have the Court of Appeals, which is 3 judges sitting without, there's no juries, there's no more facts that come into an appellate court. They only look at the record from below.
Right.
And they determine if the facts in the law were correct, or, there's a number of things you can raise on an appeal. But let's just say it's purely a legal question, and they say, well, no, the judge got it wrong, we're going to reverse the judge. And then let's just say the U.S. Supreme Court takes the case. You might have 3 judges at the Court of Appeals. You already had a judge there. Or before it gets to the Supreme Court, you can ask for an en banc hearing, and sometimes they'll give you one. It's rare, where every single judge on the Court of Federal Appeals would hear the case. And that could be 18 or 19 judges. And let's just say they all could hear, they all would see it one way and overturn their own 3-judge panel. And now that's appealed to the U.S. Supreme Court, and you have 9 justices up there. Well, they might go the opposite direction again. I mean, it's
right.
It's hard to predict sometimes because smart and every single person on that Supreme Court is brilliant, and you'll see these 5 to 4 decisions. Although most cases they all agree.
Right. Yeah. You got an 8-1. Yeah. More often than not, it's an 8-1 or a 9-0, except for the big, except for the big ones, the gray area ones that everybody's been fighting about for decades and stuff like that. We're not going down that road. Okay. So let's. Okay. So. Again, playing our ethical games, making sure we don't cross any lines here, is that we've got, I guess your focus as a judge would be timely hearings, general respectability between trying to keep the demeanors clean, for lack of a better word. What's after that for you?
Well, also just applying my experience, because I think everyone deserves a predictable judge that, I would like to think that my fellow attorneys would, if they file a case in my court, would say, well, I know that he's going to follow the law. I know that he's going to make sure he gets it right and applies the facts correctly. He's been doing it 25 years. He's had 1,000 divorce cases, or he's actually done these very intricate construction law cases where a subcontractor is sued by a general contractor and then the architect, and there's 14 different parties, and this judge is capable of putting all 14 parties into a pot, figuring out what the real facts are, in fashioning the correct remedy for the owners or all the parties involved. And if you haven't done those kind of cases, if you haven't done arbitration cases, which I've done as well, then if you're going into that court blind without that experience, it's an injustice to all those parties, especially if they have to pay to go to an appellate court to fix it, because then you're just dragging the process on longer and you're costing more money for everybody. And, people are thinking about it for this many more years when it could just be off their plate and they could be done with it.
Right, so move on to the next actual thing in their lives.
Yeah, and my goal is to try to get resolution that's get it right the first time and cut down on appeals. Another thing that judges do are conservatorships in Chancery Court. So I'm sure you followed the Britney Spears
Free Britney, yes.
saga,
yes.
and so Tennessee has its own status or its own set of laws for conservatorships, and that's a really important thing because I've represented parties that have been fighting over who's going to be the conservator. I've also actually represented the potential ward, the person like Britney. And I've been appointed as the attorney ad litem that makes sure that it's properly done, that all the procedures are met. Because once you give away someone's life and their finances to somebody else, that's a big deal. You have to make sure you get it right.
Absolutely. Interesting. See, these are this is all new to me. Like I
Sure.
get some of them because there's references from pop culture or whatever that makes sense. Britney's being a good example, but as far as the specifics of where that sits in the criminal, or not criminal, but in the justice system at large,
Chancery Court hears those cases,
right? And so trying to, because again, like I said, I pulled it up on the screen here if you want to look at it, and this is my current job description for the chancellor, and I will be using some of the information you've given me to start filling it in. It's pretty bare, the only thing I think I have right on there is that it's an 8-year term, but
right.
we're gonna expand on that as this show concludes.
They also hear things like appeals from disciplinary or from administrative hearings. So let's just say that you got pulled over and they took your car because they thought you were selling drugs. Tennessee has a civil forfeiture statute.
I know it's gross. Go ahead.
And
it's one of the rare ones I know a lot about.
Right. And so let's just say that, and I've represented people in that have been in that position where they had their car taken because they were suspected of being a drug dealer.
Right.
Well, if you think the administrative process got it wrong, then you can appeal to Chancery Court. Now, the standard's pretty high. You don't get to hear the facts all over again, but sometimes the administrative law judge will make mistakes, and you can get some relief. But if you haven't actually handled those cases, again, it's...
Right, okay, I'm sorry, we're going to off tangent here because this one is particularly interesting to me, because the way I understand it is, like you said, so I'm driving down the street, and for whatever reason the cops pull me over, they have suspicions and whatnot, and they confiscate my vehicle because that's the means of which I'm committing the crime that they think I'm committing.
They find drugs in your car.
Right, and so I get arrested, I go on trial or whatever, I get... for the sake of again, just to clarify my understanding of it, I go to trial. I get found not guilty of maybe a simple possession, but not guilty of intent to distribute or whatever the other one is, and I want my car back. I don't just automatically get my car back, which is what I think a lot of normal people would assume is I didn't get convicted of the crime they confiscated my car for, so I want my car back. And it's not just here's your car back. Sorry for wasting your time. It's it goes into your playing field, I guess. And
sure. Well, let me just say a couple of things about that. That's a policy argument. Right now, the state of Tennessee has two varying paths. You have the criminal path, and then you have the civil forfeiture path. So it's a lower standard of proof. The state can still take your car, even if a jury says you're innocent.
Right.
And some people don't like that. And there's actually lobbyists in Nashville that are trying to change that.
I'm familiar with those guys. I talk to them regularly.
Yep. And I actually was at a American for Prosperity meeting recently and talked to one of the lobbyists that's trying to get that changed because a lot of people...
Justin or Josh?
No, it was a Tory, different person.
Okay.
But anyway, but as a judge, even if I personally might find a law offensive, I'm obligated to follow it. So if the facts come in front of me and they meet the standard, as much as I don't like it, I think that it's important that judges follow the law, even if they personally are offended by what happens.
And I think that's a very important, because again, you're correct. I'm going on a policy issue which is above your pay grade, for lack of a better word, because this is a matter for a Massey or Manus, or because those are my local reps to me, and so that would be an issue for them to change the policy so that then when it does come in front of you, you have the law to go with what at least I personally feel is the logical conclusion, but it's not the current legal conclusion. That was a particular interest to me. Sorry. All right. So I paused you as you were moving through some items to do that part.
Well, we were talking about administrative appeals, and unemployment would be another example. If somebody filed for unemployment and they got denied because they were fired for cause, that could wind its way up theoretically to a chancellor. Breach of contract is probably what most people think about, or partnership dissolution as what a chancellor can do as well. So you have a business and you're fighting over how it's going to be closed down, wound up. You can have a judicial winding up of the business. And so, I've formed corporations, I've represented people in that situation. It just feels like I've had such a general practice. Almost everything a chancellor does, I've litigated. You've
been on one side or the other.
Yes.
On the other, at least on the other side of the bench, but on one side or the other of a case.
Right. I probably had too broad of a practice, because I also do things like bankruptcy, and I've also worked in the criminal arena. So if somebody were to come in my courtroom and there's a divorce case, and one of the parties is facing criminal charges, or they filed bankruptcy, I understand the interplay of the relationship of those ongoing litigations, and if you don't really have at least a working knowledge of it, you could do a disservice. And I've seen judges just freeze and say, we're going to stop everything right now. It's not always necessary that you have to stop all the proceedings just because there's a criminal case or there's a bankruptcy case.
Okay. All right. So we got a couple minutes left before I'm going to let you get on with your day, because you have better things to do than talk to me. And so we have done. We have constructed a 5-question closing. This is what we're going to do. Actually, let me pause before I do the 5-question closing. Is there anything else specific that you want to do? We'll do your actual plugs for website and campaign stuff. We'll do that at the very end. But anything specific that I may have missed that you feel is like an important thing that people might want to know about?
Well, I just hope that I can get out and meet people, and one thing I think that people ought to focus on is they're going to do a poll of the lawyers, of who the lawyers think should win these elections, and I think people should pay attention to that. I believe that the reason that lawyers will pick one candidate over the others is because of things like experience and having had cases with the specific candidates, and who actually has done the work, and who's going to do the best job, who has a good temperament,
right? And who's expectation of that expectation of a consistency of as an attorney, this is how I interpret this thing. This is how it makes sense. I know that I can bring this to your court, and you may not agree with my interpretation of it, but you will at least be open and honest about the facts of the case and that kind of stuff.
And I think most lawyers know that. I've actually filed briefs in the Court of Appeals. I've argued cases in the Tennessee Supreme Court. I've won cases in the Tennessee Supreme Court. I've won cases in the Bankruptcy Court. So I've done tons of research, legal writing. I've been to the Sixth Circuit Court of Appeals in Cincinnati, which is the federal circuit. I've got ongoing cases in federal court and state court. So I do the lawyering that I don't believe that I have the experience that my opponents don't have, right. and those things are very important.
I would think they are. So, just a curiosity that popped up while you were talking about that part of it. So, August is election day. I believe you'd swear in mid-December. Is that correct? Do you know off the top of your head?
You swear in at the end of August or early September.
August negotiations. When do you go to work? Like when do you actually?
I think right after Labor Day.
Okay, so in that month window, what do you do with current cases?
Well, you wind your cases down. You have the AOC gives you a specific amount of time to close your case. You can actually still practice for a short. I don't know if it's 90 days or 6 months. I'd have to look it up, but. With any luck, if there's no independents or Democrats running in the general, I'd start closing my practice down May 4th.
Right, that makes sense. Right, true.
In fact, I'm currently not taking any big cases right now so that I can focus on campaigning. I still have an ongoing practice. I still have to pay the bills.
Right.
But I'm doing this job because I really want to do the job. It will be a pay cut to me. I have a successful law practice now, and it's not about the money for me. It's not about titles. It's about having the right person in the job.
Okay, so since we're talking pay, do you know what the pay is for this job when it comes in?
I think it's around $170,000.
Gotcha. Because that's the list of things I'm trying to fill in on my.
That's an approximate,
job description, right? And I can. I've been trying to do some research in different places, and I know the state has a bunch of standards on certain job titles depending on the population, but it's also a state minimum, so local can change the total of it. Because I think the sheriff is minimums at like 160 something, but I think the current sheriff in Knox County makes more than that, but it has to be less than 3% of the
mayor.
The mayor, which is a funny one. But, 170 is right up there in the mayor's category because I think Mayor Jacobs is making like 188. But I'm still trying to suss out all the crazy research on that. All right, so this is it's 5 fixed questions. We're going to ask every candidate that we get in here, regardless of what seat they're seeking. These 5 questions, some of them are kind of silly. So the first one is kind of the future. Like, where is this the beginning of a further political career going into higher judging things? So the official question is have you sought a seat in public office prior to this? If so, what? And do you intend to, down the road, either continue this judgeship or go to a higher court in the future?
Okay. I'm focused on being a chancellor. I've never run for office before. This is my first foray into politics. And if I were to go to a higher court, it's actually not an elected position. Appellate court, including Tennessee Supreme Court judges, are selected by the governor after you apply to a committee.
Okay, and so those are ones that it's good to have that on the resume that you've been a judge at some level prior. That probably be helpful.
And I'm not right, and I'm not focused on higher jobs.
Right, and again, that's why I was very clear that this is a consistent thing we do. Because 8 years from now, who knows? This is a long.
Well, Judge Davis, who was a circuit court judge, who's now on the Court of Appeals. During her first term, she was elevated to the Court of Appeals.
Okay, so
within 8 years, she got bumped up.
Right. These could the one specific that you do have some aspiration towards. There is no timetable as far as as long as you get a little bit of time in as an official judge to make eligibility records. All right, number 2, what's your favorite flavor of ice cream?
I probably
told you some of them are silly. This is an amateur show on every level.
I love some of the gelatos with fruit or like extra chocolate.
I'm not going to get too specific and say that's not ice cream, but we'll let that slide. We're dealing with a lawyer here, people. They're good at answering questions. Number 3, what's your favorite place to eat here in town? What's your favorite local? Taking somebody out for dinner, or
I live right across the street from J.C. Holdway.
Okay,
so I'm drawn there quite often. James Beard Award winner.
All right, fair enough. All right, number 4. This gets back into a little bit more brass tacks. For this specific job as a judge, do you think that having these as partisan election is a benefit to the constituency, as far as candidate availability options for us to vote for? Do you think the partisanship makes that? Do you think it's a better option for the public to have these judges' races be partisan?
Well, I think as partisan races, I have an opportunity to go out and speak to local Republican clubs and get to meet folks on that basis. I think it's harder to reach out if it were to be nonpartisan. There's compelling arguments to make the race nonpartisan as well. What makes a Democrat judge versus a Republican judge.
What I was going to amend that question. I was thinking just that. I was going to amend the question to say, what do you think? I mean, is there kind of a standard difference between a Republican and a Democratic judge?
My opponent talks about having beat a liberal Democrat, which I don't agree that his predecessor was a liberal or a Democrat, but I think from perhaps at a higher level policy standpoint, if we're looking at the Supreme Court and some of the judges that were appointed there might be a difference in philosophy, but you either follow the law or you don't follow the law, and I think that's important.
Right.
and that's what should be the focus.
Right, and again, because a lot of that question comes out of the school board stuff going on right now. Just
are you qualified?
That one specific, right? What do you mean?
I said that's the question that the voter should ask. Is
right, exactly. And
is this candidate qualified to sit as judge?
Right, but I think particularly with what at least the current standing of your race is, that I think maybe a lot of people aren't thinking about, and what the partisan race does to it is it moves up this election unless we have somebody else join the race that's not a Republican.
Right.
Which I can see it as a bonus for you, because you get more time to close up your practice and take care of the loose ends of retiring from job one to move to job two. But for the general public who isn't as good, because we started in 2019. We started doing this podcast, and I didn't realize that county general was in August. Like, I didn't know that as a fact. Now, in hindsight, yes, I went and voted in some of these August generals, but I didn't understand that was a combine of state and federal primaries and the local general, because there was always a November after it. And so just in my head, general elections are always in November.
And you might not have known that there are strict rules to even become a candidate as a Republican. You have to have voted in 3 out of the last 4 primaries.
Yeah, Brandy Pace came in here. He came in early, and somewhere in one of my filing cabinets, I have the 80-something page bylaws book on it, because the Eddie Manis race, the Eddie Manis Junior Oster thing was very interesting, very early on in what we were doing, and that was a very eye-opening experience on how some of the inside the party stuff works that I never paid attention to. All right, so we rambled on question 4. Question 5, and we got to be delicate with this one, I understand, because of some of the ethical rules. But we're trying to, how do I word this? Your favorite person from the Democratic Party. Obviously not somebody running currently, because you're not allowed to endorse in that sense. But do you have a political figure, whether it's state, local, national, that you have some respect for as a leader in their party in a particular position?
Sure, I have great respect for Randy Nichols, who used to be our district attorney.
Okay,
and I would say Randy Nichols.
Okay, that closes up that. Now you plug away, get your website, get your Facebook page, whatever it is that people can learn more about you, donate to your campaign, whatever it is you want to do.
Okay. Thank you.
Go ahead.
Well, first of all, I want to thank you, Seth, for having me today. I've been a lawyer here since 1997, and my opponents have only been licensed since 2008 and 2011, respectively. I've got an opponent who's, I think, 71 years old, and my other opponent's about my age, and I think that starting off for an 8-year term at 71 is probably not ideal.
I mean, Biden's the president, but whatever.
We won't go there either. but you can reach me at Deno at DenoColeForChancellor.com, and Deno is spelled Deno.
Yes, not like the Rebel character.
That's right. And Deno Cole for Chancellor for Facebook. I've got a Facebook page and a web page. DenoColeForChancellor.com is the web page. Okay. I don't have my phone number memorized, but if you can't find me on the internet, then if you find me on the internet, you can certainly find the phone number. Okay,
then we'll do. I will put at least the website or something like that in the show notes, so it makes it a little easier for everybody to just click through and get that part out of the way. I really appreciate it. This was super educational for me as try, because again, the whole premise for me is that I know I don't know, and as much as I've tried to read up on different things, it's much harder to digest the mountain of data that's out there into a more concrete picture of what we're looking at. So on the non-campaign side of it, I really appreciate you giving us a better picture of what the job is, so that when I'm talking to other candidates and then when I'm talking to other voters about it, and it's like, well, you've decided you're voting for this person. Why? I mean, what qualification do they have that the other person doesn't? What makes more sense to you? And so I'm very appreciative of that, and I really I can't thank you enough for your time, and I wish you the best of luck, and we'll follow up from there. I got an outro, and we'll call it a day. All right, Deno Cole, everybody. Like I said, I had no idea what the job is, and now I have at least a rough picture. And so that's what we're after. That's what we're trying to do. We're trying to figure out what the job is, and then who the right person for the job is. So now we have a little bit of information on both of those things. We're Almost in Agreement at gmail.com. You can find us on Facebook, on Twitter, and on YouTube. Go to our website, almostinagreement.com. I've got a bunch of updates now to do to the Chancellor portion of the job descriptions page, but we're going to keep working on that, and I got more candidates already lined up, and like I keep joking about, I got a whole lot of people to do in a whole little bit of time. So go to your favorite podcast provider. We're on all of those as well. Give a like, share, 5-star review, whatever the thing is on those things to help push us up. So anything that pushes us up makes it easier for other people to find us. And then the best of all marketing is tell your friends about us. Tell them to their face. Steal their phone from them. Subscribe to our podcast on their phone for them. That's always a good one too. So we'll be back with more stuff. Oh yeah, breaking news. Not that it's going to be timely for anybody, but school's out again tomorrow. So enjoy another day with your kids. We've been loving it at this house, I suppose. So, Almost in Agreement, everybody. Thanks for listening.